This is the first of two videos discussing agreed upon remedies. Our first one is liquidated damages. Let's begin by defining what a liquidated damages clause is. The case on page 815 gave a definition that states, the parties to a contract may agree in advance to a sum certain which shall be forfeited as liquidated damages for breach of contract without reference to the actual damages found at the time of breach. In order to recover any monetary damages, they must be certain so that they can be calculated and paid. If damages are uncertain, then the plaintiff's out of luck and can't recover. Thus, in situations where damages are uncertain, parties create a liquidated damages provision that is a reasonable prediction of what they think the damages might be to avoid the issue of not being able to recover later on if there's a breach and the damages are uncertain. Let's break down our Red Sage case, which kind of explained how this liquidated damage clause works in practice. In 1990, the parties entered a lease that said the tenant could only use the premises as a bar or restaurant, and that the landlord could not allow another tenant to operate a bar, restaurant, or food service establishment. If the landlord violated this exclusive use covenant, the rent would be abated by 50%. So the tenant will only have to pay 50% of the rent if the landlord allows another tenant to enter the building to compete with the tenant. In 1996, the parties amended the lease that allowed the tenant to use the property as a general store and changed the rent to 6.5% of P's gross revenues or a minimum of $400K. If the exclusive use covenant was violated, this would mean half of 400K would be 200K. So the rent would now change to a minimum of 200 and 200K. In 1997, the current landlord and defendant, DESPA, accepted and agreed to the terms of the lease. Later that year, DESPA leased the space to Cake Shop. So the original landlord in 1990 and 1996 was a landlord who had an interest in the plaintiff's business. DESPA bought the landlord's business or building, and then now DESPA is dealing with the plaintiff. Red Sage, the plaintiff, sought a declaration that its new landlord, DESPA, had breached the exclusive use covenant by allowing the cake shop to enter. The trial court held that the rent abatement of 200K would impose an improper penalty. Again, Red Sage only has to pay 50% of the rent, and the minimum rent they'd have to pay is 400K. So the minimum rent at 50% is 200K. What were the issues addressed by the court? The first one is whether the rent abatement clause is a liquidated damage clause or a contractual provision adjusting rent in response to changed circumstances. This is significant because a liquidated damage clause is viewed with more scrutiny versus just a contractual provision adjusting rent that doesn't have to meet extra requirements to be valid. The second issue is, if this is a liquidated damage clause, is it valid? The court held this clause is a liquidated damages clause and that it is valid. Let's start with the reasoning behind why this is a liquidated damage clause. The rule used by the court to determine its holding was on page 814, paragraph 3. When there's doubt as to whether the parties intended to provide for a legitimate liquidated damages, courts routinely construe liquidated damages provisions as penalties and thus decline to enforce them to prevent forfeitures. Essentially, that means we look at the party's intent to determine whether this is a liquidated damage clause or a penalty for breaching the contract. Remember, the goal of contract law is to compensate the plaintiff for the loss, not to punish the defendant for breaching the contract. And that's why we don't like liquidated damages clauses that are punishing, not compensating for the breach. There's a specific clause that said that rent shall be abated if their landlord violates the exclusive covenant, and that the rent abatement shall not limit any other remedies which tenant may have against the landlord. The court said this language strongly suggested that rent abatement is a remedy for the violation of the lease, rather than a mere adjustment for changed circumstances, which suggested this is more of a liquidated damage clause than just a regular provision. And so here, the court's showing us how to analyze a party's intent by looking at the written language. Other two things you should look at are the negotiations as well as the timing that happened between the parties when they were negotiating this contract. So here we have written language, the word violates the lease, you get a remedy. And then you had negotiations where you had two sophisticated parties, DESPA and Red Sage. We also had timing where this restriction didn't exist in 1990 when the landlord actually had an ownership interest in Red Sage. It was changed in 1996, 1997, but because DESPA was involved in the negotiations and agreed and accepted it, it suggested that DESPA understood the risks or understood this clause when it entered it. And then finally, other courts have held double rent as a liquidated damages clause, which means paying only 50% of the rent by the tenant could also be a liquidated damage clause. It's just something that goes against the landlord, whereas double rent goes against the tenant who violates a lease. So here we have a liquidated damages clause. The next issue is, well, is it actually valid? Right? The parties intended to create a liquidated damages clause, not a contractual provision adjusting the rent, but can we enforce this? The rules used to determine the court's holding, which was yes, we can enforce it, was first that a liquidated damage clause must be a reasonable forecast of the actual damages, and of course, not a penalty. Again, we don't want to punish, we're trying to compensate. A reasonable forecast of actual damages, the court states, will usually either overestimate or underestimate the damages. Because liquidated damage clauses are created and implemented in situations where damages are difficult to estimate, you'll have a hard time determining the exact amount. And so here, the analysis of our situation on page 816 was the anticipated damages from the cake store would definitely be less than the 50% base rent, right? Red Sage probably didn't lose 200K worth of profits because the cake store entered the building. But if a more competitive restaurant entered, not just a cake store, there's a chance that Red Sage could have lost more than 200K, right? So it's overestimating and underestimating Red Sage's possible damage. So here it's a reasonable forecast because it's not certain that Red Sage will get a windfall from any breach of the contract. Red Sage could get more, but Red Sage could also get less. And it's not a penalty because it's not saying that Red Sage doesn't have to pay any rent. It's just reducing the amount of rent because the value of Red Sage's tenancy in the building goes down when it has a competitor. This means the clause treats Red Sage and DESPA equally because DESPA could end up paying more than Red Sage's actual damages, but it could also end up paying less than Red Sage's actual damages. Different than the Davy case mentioned in the opinion that allowed a fixed sum to be forfeited as liquidated damages for breach of any covenant, and that included major and minor breach. It didn't consider the nature of the breach, whereas here was only 50% of a specific clause, the exclusive use agreement, not the whole contract itself. The other rule the court used was on page 815. It stated that parties could reasonably have believed the damages resulting from the breach of an exclusive covenant would be difficult to ascertain, rendering future litigation uncertain. And that means liquidated damage clauses are only really enforced or appropriate when you're unsure what your damages will be if someone breaches that clause or that contract. So damages must be uncertain at the time of formation for a liquidated damages clause to be enforced later and valid. And here the analysis was on page 815 to 816, where it talked about new competitors, lost sales, lost opportunities, loss of goodwill. These are all intangibles that are very difficult to measure and very difficult to predict, especially when we don't know what type of competitor might be entering the building. Now, what kind of rule do you actually use on the exam? The actual rule was on page 815, paragraph 3, which was a giant paragraph. But how would you organize this rule paragraph into something that you can memorize and actually create headings and subheadings for? Well, for the exam, the rule that I recommend memorizing is a liquidated damage clause is valid if the parties intended to provide a liquidated damages clause. It would be difficult to ascertain the actual damages if the contract was breached at the time of formation. And the agreed upon amount is not a penalty. It does not make breach of the agreement more profitable than performance. And the agreed amount the agreed upon amount is a reasonable prediction of the damages that would flow from the breach. It can't be more than damages reasonably expected, right? So it has to usually will overestimate as well as underestimate what the damages could be. And then finally, the agreed upon amount has a reasonable relation to the probable damages that will flow from the breach. The three hardest ones to sometimes understand are 3, 4, and 5, where number 3 deals with we don't want them to have a windfall, so don't want to punish. So we need to find something that is going to be, again, the fourth one, an actual reasonable prediction of what the harm could be. Or the fifth element looks kind of similar to the fourth one because it deals with reasonableness, but it's actually dealing with causation, where the amount has to be reasonably related to what the breach actually would be. But for purposes of the exam, let's simplify it and not deal with the fifth one because it actually kind of shows up in the fourth element, where you still have to have a reasonable prediction of damages that would flow from the breach. So the prediction must be good in the amount as well as related to the breach. The other two sub rules are based on circumstances and expectations at the time of execution. And if valid, no proof of actual damages are required to enforce a liquidated damage clause. So even if you had no actual damages, you can still enforce a valid liquidated damages clause to collect. And this is why we look at them with such scrutiny, because if there's no actual damage, there could be a significant windfall. On the flip side, it might also not compensate the plaintiff fully for the actual harm and give the defendant pretty much a free card for breaching the contract. So we want to make sure that, again, it's a reasonable prediction of the damages, but also not a penalty to balance that compensating the plaintiff, but not punishing or causing a windfall.